I feel like I'm drowning and everybody is just watching me drown. And it kind of sucks because everyone's watching me drown because I chose to swim a different way. It's just too much. I completed my full federal complaint along with the full evidentiary record. Yeah. And it's in this box. I think you guys can see it, but this is the full complaint with the full evidentiary record, including the flash drive for videos and ring footage and voicemails to support my evidentiary record. This entire box is not the full complaint, only this is the full complaint. And everything else is the supporting evidentiary record of everything that's transpired. And as I already told you guys, I only submitted the emergency complaint because of the escalation of things. But this was originally supposed to be my federal complaint. And I also shared that the TRO that I submitted was not accepted. So I put in an appeal for it. But I didn't know like some of the background things of how things work because it's not listed anywhere online. It's not on the websites. So pretty much when I filed my emergency complaint, I had 21 days to amend it to the full complaint, which is this complaint. And I was also going to submit the full evidentiary record. And today I went to court to file everything, and they told me that I could not file it because right now the appeal court has jurisdiction, which was not explained or expressed anywhere that I looked. As did I already issue a response to the appeal court today before I went to the fucking federal court to file my full complaint with their evidentiary record. And I ended up having to send another motion to file everything onto the federal court through the appeal court. I had to submit the motion through the appeals court to file everything that I've already done onto the record at the federal court so they can see everything in its totality. I'm very fucking annoyed. I'm exhausted. This takes so much stuff. I don't think that people clearly don't understand. I really don't give it. I don't think people care neither. So it's like I'm just fighting against the whole fucking world, it feels like, by myself, and everybody is just looking at me do that. I did supply a copy of the completed complaint to the appeals court for reference in support of allowing the motion for me to file everything onto the record. And I also want to share the full federal complaint with you guys. I feel like everybody already know where I live anyway, but this is the full federal complaint. These are the defendants. I believe these are also the defendants. And these are also the defendants in my current case at federal court. I'm gonna just take this paper. Then we get into the table of authorities. Another table of authorities. And we have the table of contents for the exhibit index, which is just expressing everything that I am submitting as far as evidence. This is 3 pages. And then we finally get into the complaint, which I am going to read to you guys, just so you know how these things work. Have some insight. I, Heaven-Marshay Hope, a living woman, a natural-born, non-citizen, national, and lawful resident of Ohio, domiciled without the corporate United States jurisdiction, appear in proper person and authorized representative. One of the indexes that I created for the evidentiary record is a definition exhibit, which references or expresses the definitions of some terms that's included in the complaint. So like authorized representative is one of those words, and then it lists the exhibit and the number that you could find that definition under. I'm not doing that. I'm not even gonna go beyond like mentioning the exhibits past this point. I just wanted to let you guys know that that's in there. Appear in proper person and authorized representative capacity, reserving all rights without prejudice under UCC 1-308 and 1-103. I bring forth this verified complaint, accompanying affidavits and supporting evidence as a matter of public and federal record. This action is filed in the United States District Court of the Northern District of Ohio, pursuant to 28 U.S. Code 1331, federal question jurisdiction, as this matter arises under constitutions and laws of the United States. 28 U.S. Code 1343, civil rights and equal protection jurisdiction involving deprivation of rights under the color of state law. 42 U.S. Code 1983 for violations of civil rights and due process. 42 U.S. Code 1985 for conspiracy to interfere with civil rights. The 4th, 5th, and 14th Amendments of the United States Constitution. Additional jurisdiction is invoked under the Universal Declaration of Human Rights, Public Law 97 280, 18 United States Code 242, Declaration of Rights under the color of law, 18 United States Code 241, Conspiracy against rights, and applicable administrative law. For clarity to eliminate semantic disputes, all defined terms used in this complaint carry the same intended meaning regardless of tense, form, or grammatical variation, as outlined in Exhibit X applicability of terms. Venue is proper in this court under 28 U.S. Code 1391B as the events, deprivations, and injuries giving rise to action occurred within the territorial boundaries of the Northern District of Ohio. Plaintiff presents ongoing injury resulting from actions and omissions committed by both public officers and private actors acting in conspiracy under the guise of law, commerce, and institutional procedure. These acts have caused unbearable harm and a pose of continuing threat to plaintiff's safety, freedom, property, and family. Plaintiff seeks declaratory and injunctive relief, lawful remedy, commercial restitution, and punitive damages as outlined in the accompanying statement of claims. Statement of facts. The plaintiff, Heaven-Marshay, has exhausted every possible administrative, legal, and peaceful avenue to obtain remedy prior to bringing this to federal action. Despite diligent and repeated efforts to resolve the ongoing violations of rights, safety, and authority as a lawful guardian, plaintiff was continuously met with dismissal by public officers and agencies, coercions from courts and institutional actors, gaslighting and minimization of lawful filings and complaints, blatant disregard of legal standing, documentation, and procedural requirements. Plaintiff have submitted numerous notarized affidavits, sworn declarations, and administrative complaints and formal notices, all of which cite applicable laws, codes, rules, statutes, constitutional provisions, and case law as clear supporting evidence of due diligence and lawful standing. These submissions were either ignored, returned without action, or met with contradictory and retaliatory responses, reflecting a clear pattern of negligence and obstruction. At this point, one of the two conclusions must be drawn. Individuals and agencies are deliberately and maliciously violating the plaintiff's rights, refusing to uphold and enforce clearly established law, or there exists a dangerous level of ignorance, incompetence, or systemic conditioning that render these situations incapable of lawfully performing their duties. Regardless of intent, the impact has the same unbearable harm to the plaintiff and her minor children, mentally, emotionally, physically, and spiritually. This pattern of behavior constitutes not only gross negligence, but a chronic and unlawful denial of rights that's resulted in a full evidentiary record of constitutional, administrative, and commercial violations. The plaintiff bring this federal suit not out of convenience, but out of necessity in defense of fundamental human and lawful rights. Condensed timeline overview. The plaintiff's evidentiary record document reference Exhibit D spans over a year beginning from April 2014 and contains notarized affidavits, administrative filings, certified mail receipts, and official responses or lack thereof numerous public and private actors. The timeline reflects repeated violations of right, disregard of lawful process, and intentional or negligent acts resulting in ongoing harm to the plaintiff and her children. Key events documented included 2014 to present, well over 150 documents, lawful filings, including affidavits of truth, notices of claims, and affidavits of disqualification submitted to local, state, and federal agency, consistently ignored and returned without lawful rebuttal. July 2021, first extradition attempt via notice of claim included submission of Standard Form 95, a complied evidentiary record, and previously submitted documents such as the writ of quo warranto and supporting clinical documentation, thereby establishing both harm and standing. October 2024, the affidavit of disqualification was filed onto the record at the Supreme Court of Ohio, yet was ultimately denied despite the plaintiff citing case law codes, laws, and statutes, none of which were rebutted. Nevertheless, the acting Chief Justice proceeded to deny this filing. I was unaware that reporting a crime could be refused. During this time, Standard Forms 56, 1041V, 1041, 1096, and 99 OID were also submitted to the Internal Revenue Service in efforts to access trust funds. This access was unlawfully withheld and formally reported to ICE, which holds a moral, ethical, and legal obligation to address and correct fraud. September through December 2024, a formal complaint of fraud and rights violations were submitted via W-4 sandwich to the Department of Treasury Remittance Department, accompanied with a cover letter for W-4 sandwich for court and cover letters for W-4 sandwich for ODJFS. The first formal submission of negotiable instruments prepared in accordance with the UNCITRAL Convention and Negotiable Instruments Act of 1881 was rejected without lawful cause. December 2024, federal agencies were formally notified of persistent harm and ongoing right violations experienced by plaintiff through submission of standards 211, Forms 211, 39, Forms 211, 3949A, and the SECTRC form. These submissions included the Affidavit of Truth for Form 3949A for Chief Justice and the Affidavit of Truth for Form 211 for the Internal Revenue Service. January 2025, the Ohio Disciplinary Council was formally notified after the Department of Justice redirected plaintiff for proper complaint filing. Submissions included the Affidavit of Truth of the Ohio Disciplinary Council for Courts and the Affidavit of Truth for the Ohio Disciplinary Council for Chief Justice. Despite the inclusion of the notarized documents citing case law, statute codes, and applicable laws, the matter once again was addressed without lawful rebuttal. March to May 2025, the first formal complaint for failure to process negotiable instruments was submitted to both the Consumer Financial Protection Bureau and the Federal Reserve. Submissions included the formal complaint for failure to process negotiable instrument for the indenture trustee to the Consumer Financial Protection Bureau. During this period, the illegally assigned guardian ad litem was formally removed from services through the discontinuation of legal services. Formal cease and desist notices were sent to Cuyahoga County CPS and the Ohio Director, Department of Children and Youth, accompanied by the Affidavit of Fact and Notice of Jurisdictional Challenge, demand for evidence and cease and desist. New negotiable instruments were submitted to Penske Automotive Group after being redirected by their indenture trustee through the Consumer Financial Protection Bureau. ICE's refusal to assist in the ongoing matter was formally challenged via the formal demand for rebuttal and accountability for ICE. The court received a multitude of affidavits which remain unacknowledged and unrebutted, including but not limited to notice of custodial authority and non-consent to third-party interference, the affidavit of personal knowledge, and a notice of federal violation. June 2025, ongoing plaintiff initiated a call for support and formally requested assistance from multiple individuals via request for support and public awareness. The wrongful suspension of the child's counseling service was formally challenged through the affidavit of legal and lawful custodianship and notice of temporary disruption through therapeutic services. Unlawful attempts to sue the plaintiff were initiated by Javich Block LLC in the Bedford Municipal Court, formally challenged through the affidavit of clinical boundary and custodial rights clarification. What the fuck? That's wrong. Further, unlawful attempts to alter custodial authority under the color of law resulted in authorities appearing at the plaintiff's home with stated intent to remove child by any means necessary. This is formally challenged to the affidavit of harassment, unlawful enforcement, and witness intimidation for court. This evidentiary timeline establishes a clear pattern of misconduct, obstruction, escalation of harm. It demonstrates that all defendants were provided repeated opportunities to address violations to secure lawful remedy, but instead engaged in acts both of commission and omission that worsened the plaintiff's injury and compounded the deprivation of rights. Statement of facts. In November 2023, plaintiff submitted a package to the Internal Revenue Service challenging its jurisdiction to impose federal income tax. On December 4, 2023, the IRS acknowledged the plaintiff's receipt of submission. Thereafter beginning in March 2024, the plaintiff received repeated automated responses approximately every 3 months, each stating, "We need more time to provide you with a complete response." In December, the plaintiff received another letter from the from the Internal Revenue Service dated December 18, 2024. Plaintiff received a response addressed as Heaven-Marshay Hope TR and Heaven Hope TTEE. This was a notable departure from the prior correspondence, which consistently addressed plaintiff as Heaven M. Hope. This response stated, "This is in this reply to your correspondence received December 4th, 2023. We have determined that the argument you raised are frivolous and have no basis in law. Federal court has consistently ruled against such arguments and imposed significant fines for taking such frivolous position." The response was accompanied by attachments entitled Taxpayer Bill of Rights and Don't Fall for These Arguments. On December 26, 2024, the plaintiff received almost another identical letter, only this time it was addressed to Heaven M. Holt and Heaven M. Holt TTE. In response, plaintiff submitted a standard forms 211 and 3949A to the IRS whistleblower office, formally reporting the misconduct. Despite this, the automated responses continued, addressed once again to Heaven M. Holt. Since April 2014, plaintiff has endured a pattern of psychological warfare that has escalated to post-traumatic stress disorder. The plaintiff submitted 6 separate requests to the Cuyahoga County Court of Common Pleas Clerk of Court seeking the legal representation of the defendant Isaiah Miles Nash. These requests were ignored. Exhibits documenting these requests includes a certificate of service, cover letter, supplemental notice of experience, certificate of service. The plaintiff's home is no longer safe due to continuous harassment, intimidation, and unlawful intrusion. The plaintiff's character has been repeatedly slandered and devalued by defendants through unlawful orders and warrants issued under the code of law. Plaintiff and her children have suffered severe mental, emotional, and physical and spiritual harm due to bullying, harassment, stalking, retaliation, and unlawful seizure/kidnapping of the plaintiff's child. Plaintiff's lawful rights have been violated, withheld, or ignored. These include repeated denials of plaintiff's lawful request and recognition, filing of her declaration of status, denial of right access to her trust property and accounts, refusal to honor plaintiff's lawful means of purchase via negotiable instruments, denial of lawful relief through state assistance programs. Plaintiff has exhausted every available administrative and lawful avenue for resolution prior to this federal filing complaint. All parties were duly notified and failed to respond, either through gross negligence and ignorance or through intentional disregard of plaintiff's rights, each causing additional harm. Plaintiff have gone beyond due diligence, citing applicable laws, statutes, codes, and case law in support of her claims within every filing. Despite this, defendants either ignored, contradicted, or retaliated against plaintiff, thereby compounding these violations. Plaintiff has also documented instances of clerk misconduct. The most recent occurred August 8th, 2025, when plaintiff was forced to resubmit the filing after the clerk's office returned the original documents claiming your filings are missing case number, despite 3 submitted documents plainly displaying the case numbers on the first page. The resubmission was sent August 9th, 2025, where the court only to return the submission, contradicting the reasoning of the first return, as well as the fact that all of the documents filed onto the record by the same clerk's office doesn't include the case number. Related exhibits include the notice of continued interference, record of unauthorized contact, and reaffirmation of removal for GAL, final notice of the liability, defamation, retaliation, and demand for rebuttal, certificate of service. Plaintiff and her minor children continue to endure unbearable harm mentally, emotionally, physically, and spiritually, directly caused by the defendant's ongoing violations of constitutional and civil rights, misconduct, negligence, and retaliation under the color of law. These harms include unlawful seizures/kidnapping and deprivation of plaintiff's child, loss of safety and stability within the family home, reputational injury through slander and defamation, and the daily trauma of being denied lawful remedies despite diligent pursuit. The continuation of these violations compounds the injury with each passing day, creating an urgent, ongoing threat to plaintiff's rights, family integrity, and well-being. Plaintiffs and her minor children continue to endure unbearable harm mentally, emotionally, spiritually, and physically, directly caused by defendants' ongoing violations of constitutional, civil, and commercial rights under the color of law. These violations include but are not limited to the unlawful disconnection of essential utilities by the illuminated company, the refusal to process lawful negotiable instrument, thereby denying her rightful access to a vehicle, home, and private credit, Re- repeated obstruction and delay by the Internal Revenue Service in granting access to the plaintiff's trust. Each of these acts not only strips the plaintiffs of basic human needs and lawful entitlements, but also compounds the trauma of family separation, harassment, and defamation, creating an ongoing and intolerable pattern of harm. On August 18, 2025, plaintiff personally observed defendant Isaiah Miles Nash engaging in suspicious and concerning behavior outside of Tower City in Cleveland, Ohio. Plaintiff was seated inside of a vehicle belonging to Eric Jelante Dowry Jr. when the defendant approached the area from behind the vehicle. Instead of simply continuing along his path, defendant deliberately turned his head and looked directly into the passenger side window of the vehicle. The plaintiff was seated in the driver's seat. This conduct is highly concerning, given the plaintiff was inside a vehicle that does not belong to her, which the defendant had no lawful reason to associate with her. The defendant's deliberate action of looking into the vehicle suggests intentional surveillance or monitoring of plaintiff. The incident follows a pattern of coercive obsession and retaliatory behaviors previously documented by the plaintiff against defendant. Such behaviors heighten plaintiff's concern for her safety and further support the claims of harassment, coercion, and psychological warfare portrayed by the defendant. Plaintiff initially and voluntarily initiated safe and sound services solely to confirm her capabilities as the minor's child's mother without court involvement. Plaintiff formally informed the Cuyahoga County Court of Common Pleas Clerk of Court of this initiation through the Notice of Custodial Authority and Non-Consent to Third-Party Interference. However, the court subsequently weaponized this arrangement to force compliance in response. Plaintiff expressly notified the court that safe and sound was no longer a viable option. Despite this formal notice, defendant Isaiah Miles Nash has continued to reference safe and sound as though it has remained operative in the direct regard of plaintiff's filings, such as the unlawful seizure of the plaintiff's minor daughter on August 13, 2025. Defendant has referenced visitation through safe and sound on August 15, 2035 and August 19, 2035, implying that it remained a lawful outlet for visitation. This conduct is not only severely triggering for plaintiff, but also constitute bad faith, coercion, and retaliation under the color of law. It further demonstrates the court's ongoing failure to provide plaintiff's rights and to honor plaintiff's rights and duly submitted notices. On August 19, 2025, a FaceTime call with minor child Nevaeh Naomi Nash, 9. Plaintiff observed was seated in the front seat of the passenger as of defendant's Isaiah Miles Nash vehicle without a seatbelt fastened while the defendant was operating the vehicle. When plaintiff raised concern, defendant replied, because she didn't put it on, thereby improperly shifting responsibility for safety compliance onto the minor child. This conduct constitutes gross negligence and endangerment. The 9-year-old cannot be held solely responsible for her own safety in a moving vehicle. The duty rests upon the supervising adult to ensure the child is properly secured before driving. Defendant's conduct demonstrates not only physical endangerment, but also emotional harm. He consistently shifts adult responsibilities onto minor child, thereby coercing and burdening her with the blame for his own negligence. The foregoing facts establish a clear and consistent pattern of misconduct, gross negligence, and retaliation carried out under the color of law by both public officers and private actors. Plaintiff has exhausted every lawful and administrative avenue to resolve this matter without litigation, yet her rights, remedies, and protections have been repeatedly ignored, obstructed, or outright violated. These acts have not only inflicted irreparable harm onto plaintiff and her minor children, but also demonstrates a systemic abuse of authority that strikes at the very foundation of justice, due process, and human dignity. These injuries are ongoing and immediate and incapable of remedy through ordinary state channels, thereby necessitating the federal intervention. Plaintiff brings this action not in a haste or convenience, but out of urgent necessity to protect her family, enforce her rights, and hold all responsible parties accountable under law. Systemic orchestration of harm. The plaintiff asserts that the cumulative nature of the violations detailed through this complaint are not isolated incidents, errors, or miscommunications. Rather reflect a deliberate, coordinated orchestration of harm enacted by multiple agencies, entities, and individuals operating under the color of law. The plaintiff has repeatedly been subjected to retaliatory actions, procedure irregularities, withheld remedy, coercive custody shifts, and weaponized administrative processes, all of which suggest intentional alignment among institutions designed to suppress, confuse, discredit, and control. This organization has resulted in a compounding emotional, psychological, legal, and spiritual injury to the plaintiff and her children. The timing, nature, and structure of these events are reveal not randomness but design, a systemic manipulation of due process, remedy access, and constitutional protections. Whether driven by institutional ignorance, program obedience, or outright malice, the orchestration constitutes a grave abuse of power and demands federal intervention. The plaintiff reserves the right to expand on the nature of this organization with accompanying exhibits in Definition Index X. Statement of Claims. Claim 1. Violation of civil and constitutional right. 42 U.S. Code 1983 and 1985, 4th, 5th, and 14th Amendment. Defendants acting individually and in concert deprive the plaintiff of rights secured by Constitution and federal law under the color of law as defined in. These violations include unlawful seizure and deprivation of custodial authority without a verified injured party, without proven jurisdiction, and without due process. The orchestration of these acts is evidence in Exhibit D, which detail a chronological pattern of administrative dishonor, procedural fraud, and retaliatory acts. This record captures the complete orchestration of harm, hardship, and violations committed by all involved parties, regardless of the lawful submissions made to due diligence exercised on the plaintiff's behalf, and challenges that the plaintiff has consistently addressed, including jurisdictional challenges and obstruction, since April 2024. Defendants' categories and roles: local actors, Bedford Police Department, Cuyahoga County CPS, the legally assigned guardian ad litem, Cynthia A. Ernst, the Cuyahoga County Court of Common Pleas, and the clerk of court, acting magistrate Elizabeth Howe, acting judge Nicholas J. Celebrez, has direct involvement in unlawful custody, interference, obstruction, and administrative retaliation. State actors: Governor Mike DeWine, the Chief Legal Counsel Matthew J. Donahue, the Ohio Supreme Court, the Ohio Department of Job and Family Services, Acting Director Matt Dan Stroder, the Ohio Department of Children and Youth, Acting Director Carrie B. Wente, the Ohio Secretary of State, the Ohio Supreme Court of Ohio, Acting Chief Justice Sharon L. Kennedy, the Office of Disciplinary Counsel facilitated, condoned, and failed to correct violations after receiving due notice. Federal actors: the Department of Justice Civil Rights Division, the Department of Health and Human Services, the Federal Trade Commission, the Consumer Financial Protection Bureau, the Department of Treasury, Acting Secretary of Treasury Janet L. Yellen failed to enforce protective statutes and acted in bad faith. Private entities: Our Family, Wizard Javich Block LLC, Alley Bank, the Illuminated Company, care of First Energy Corp, participated in participated knowingly in violations of commercial game constituting commercial injury. Private individuals, non-corporate actors, Graveyard Group Counseling, owner Deborah Ornowski, Molly Bogner, LSW, LPCCS, and Isaiah Miles Nash, private individuals whose personal acts and omissions contributed to the violations herein, whether intentional or unintentional. In direct regard of defendants' involvement, regardless of the role, being ignorant does not excuse the harm endured. Supporting legal authority. Morrow versus Pope 365 U.S. 167 1961 confirms that the state's actors can be held liable under 1983 for violations of constitutional rights, even if the acts were unauthorized by state. Zinnerman versus Birch 494 U.S. 133 1990 due process violation occur when officials fail to provide accurate procedural protections before depriving someone's liberty or property. Troxell versus Granville 530 U.S. 57 2000 recognizes the constitutional right of guardians to make decisions concerning care, custody, and control of their children. Claim 2, conspiracy to interfere with civil rights. Defendants, whether intentional or unintentional, willfully conspired to deny plaintiffs of lawful rights, equal protection, and due process by coordinating unlawful acts, misrepresentations, and administrative obstructions. These acts were not limited to judicial officers. All defendants engaged in conduct amounting to fraud under the color of law despite being provided with due notice and clear opportunities to correct their actions prior to federal filing. Such acts included fraudulent court filings, fraud upon the court, issuing void orders without lawful jurisdiction, void ab initio, commercial misrepresentation and the misuse of lawful court orders and warrants, deprivations of rights by refusing legal tender in form of negotiable instrument, a direct violation of Universal Declaration of Human Rights occurred in numerous ways and was expressly communicated to state actors through multiple submitted documents. The conspiracy is evident in subsequential and reciprocal actions detailed in Exhibit D, document reference, exhibiting chronological harm caused by both public and private actors, each contributing to the organization of violations through acts of commission and omission. The plaintiff has made numerous attempts to enforce her rights with all involved parties, yet violations persist. No defendant has demonstrated the ability or willingness to exercise due diligence. Supporting legal authority. Actits versus S.H. Kress & Co. 398 U.S. 144 1970 establishes that public and private actors can be jointly liable if they conspire to deprive someone of equal protection or due process. Dennis versus Spark 9449 U.S. 24 1980. Private parties who conspire with judges or officials to violate rights can be sued under federal civil rights statutes. Claim 3, deprivation of custodial authority and family integrity. Defendants engaged in custodial interference and kidnapping under the color of law, bypassing lawful procedure and ignoring absence of proven crime. The deprivation caused unbearable harm to the plaintiff and her children, violating fundamental liberties, interest recognized under the 14th Amendment. Wrongful suspicion of child's counseling services as a direct result of persistent violations, falsely justified under the color of law. Exhibit D, document reference, provides a documented timeline of repeated administrative retaliation, ignored affidavits, unrebutted affidavits, and bad faith refusal to correct harm. My custodial authority was never lawfully transferred to another individual. However, under the color of law, it was wrongfully perceived as such, causing an unbearable amount of harm. Supporting legal authority. Santosky versus Kramer 455 U.S. 745 1982. Termination or interference with guardian rights requires clear and convincing evidence and strict due process. Stanley versus Illinois 405 U.S. 645 1972. States cannot deprive a parent of custody without proven unfitness through proper judicial process. Claim 4, fraud, procedural fraud, and abuse of power. Defendants committed fraud, procedural fraud, and abuse of process by using court system, administrative agencies, and commercial actors to deprive plaintiff of rights and property. Fraudulent documents and misrepresentations were used to create appearance of lawful authority, color of law, while bypassing lawful requirements. Exhibit D entries show a reoccurring refusal to rebut affidavits, honor lawful contracts, or recognize negotiable instruments. It is fact that the right to travel, the right to health care and food, the right to essential utilities such as gas, electricity, and water, and the right to the land are fundamental rights, yet these have been repeatedly misconstrued as privileges and treated unlawfully despite the Universal Declaration of Human Rights, the Constitution, and applicable statutes and rules, all of which have been cited by plaintiff and submitted to the proper entities for enforcement. Claim 5, commercial injury in bad faith in commerce. Defendants acted in bad faith in commercial dealings using commercial injury through unlawful demands, denial of lawful remedy, and refusal to honor binding agreement and instruments. Actions violated provisions under the Uniform Commercial Code and federal consumer protection laws. Exhibit D document reference evidences the harm through ignored demands, remedies, improper defaults, and refusal to process lawful forms by state and federal actors. Failure to process the plaintiff's negotiable instrument and default judgments by refusing or failing to revoke lawful affidavits, despite the plaintiff's citation of laws, statutes, codes, and rules supporting the filings in their entirety, including the UNCITRAL Convention and the Negotiable Instrument Act of 1881, constitutes a direct violation of rights. The Ohio Secretary of State's refusal to file the plaintiff's declaration of status has severely impacted the plaintiff's rights as the authorized representative of the estate and trust created in her name by the government. This conduct unequivocally qualifies as extortion, fraud, as it denies the very individual whose name has been maliciously used to create a secret trust the lawful authority to access, manage, and protect it. Such actions represent a calculated obstruction of remedy and willful perpetuation of harm carried out under the color of law and in breach of the most domestic and international commercial obligations. Support and legal authority. Haynes versus Kerner, 404 U.S. 519, 1972. Pro se litigants' filing must be held to less stringent standards, especially when addressing commercial harm and constitutional rights. Perry versus Sinderman, 408 U.S. 593, 1972. A government entity cannot retaliate against an individual for exercising constitutional or contractual rights. Relief requested: immediate enforcement and release of all commercial instruments previously created, including but not limited to the vehicle. Immediate enforcement and release of all commercial instruments previously created, including but not limited to vehicle, black card, and property, with unrestricted access to private trust, tangible restitution in the form of a fully insured and secured private vehicle of my choosing, clear and encumbered title to private land and real estate, and an unlimited, unrestricted private credit line, full insurance. 3 full insurance settlements included but not limited to vehicle insurance claim settlement, home and property claim settlement, health and generational life insurance, compensation for myself and my children, filing and federal recognition to the plaintiff's declaration of status, ensuring acknowledgement and enforcement of plaintiff's lawful standing, rights, and protections throughout all the United States jurisdiction and territories without restriction, limitation, or condition. and in full alignment with the constitutional provisions and the Universal Declaration of Human Rights and applicable treaties. Federal acknowledgement and permanent protection of lawful rights, freedoms, and inheritances of the plaintiff's children and generational bloodline to ensure the rights extend beyond the plaintiff's lifetime and are preserved without restriction, limitation, or condition, regardless of whether such individuals have personally engaged or contributed to the plaintiff's lawful defense or remedy efforts, full legal and beneficial ownership, control, and unrestricted access to all trusts, estates, accounts, and property created in the plaintiff's name, in the name of the plaintiff's children, with immediate removal of any unauthorized third-party claims, trustees, or restrictions, public correction and record sealing, all defamatory and harmful records, including the correction of court filings, administrative records, and publicly accessible data, written acknowledgement of ondoings by all responsible agencies, agents, and entities involved. The immediate suspension of all state and local court proceedings, orders, and enforcement actions related to the plaintiff's right violations pending final adjudication of this matter in federal court. Punitive damages in excess of 20 million USD fiat equivalent, proportionate to the harm, violations, and losses detailed in the statement of facts and exhibits, and now formally sought through this federal action. These remedies represent the minimum lawful restitution and corrective measures necessary to address the harm endured. They are non-negotiable given the scope, duration, and orchestration of the violations committed. Equitable sanctions for non-compliance, daily equitable compensation for unlawful deprivation of custody for every day beginning August 13, 2025, the date of unlawful seizure, and continuing until the plaintiff's minor daughter is returned to her lawful custody. Defendants included but not limited to the Cuyahoga County Court, Bedford Municipal Court, Isaiah Miles Nass, and Bedford Police Department shall be jointly and severely liable for daily equitable compensation. Accrual formula: these daily equitable compensations shall occur at the minimum equivalent of $25,000 US dollars per calendar day, enforceable through equitable remedies, trust enforcement, property conveyance, insurance settlements, credit authorizations, correction of records, issuance of insured assets, and other equitable relief or other court order performance at the plaintiff's sole election. This compensation shall occur not in fiat or monetary terms alone, but in enforceable equitable remedies, including but not limited to the immediate enforcement and transfer of the plaintiff's declaration of status and lawful standing in the federal level, restoration of plaintiff's unrestricted access to her private trust accounts and negotiable instruments, conveyance of clear property title or real estate or of equivalent value, provisions of secure transportation, insurance settlement, and credit authorization of equivalent value, any other equitable remedy that restores plaintiff to the position she would have accompanied but for the defendant's unlawful actions. Defendant's inability to directly access or administer plaintiff's trust or estate shall not exclude performance. Instead, defendants remain liable to satisfy this accrued obligation through court-ordered transfers, settlements, and performance until plaintiff has been made whole. All parties involved shall be held to the fullest accountability permitted by law. No action, behavior, or choice contributing to the unbearable harm inflicted upon the plaintiff and her children will be excused or overlooked. Settlement parameters and non-negotiables of equitable relief. Plaintiff explicitly places all parties, counsel, and court on notice that any resolution of this matter, whether through settlement, stipulated judgment, consent decree, or other lawful means, shall be conditioned upon the public recording of the agreement and full execution of the equitable and specific performance release enumerated herein. These terms are non-negotiable and are not an offer of compromise, and are set forth in advance to ensure that no private, off-the-record agreement or conditional arrangement can be misrepresented as a resolution. These provisions is intended solely to predefine the parameters of lawful settlement and safeguard plaintiff's rights, remedies, and record of enforcement purpose. Equitable and specific performance relief in events of settlement or judgment. In the event of settlement or judgment in the plaintiff's favor, defendant shall, within 15 calendar days of the settlement execution or entry of judgment, cause plaintiff's declaration of status and all associated lawful records to be formally filed, recorded, and recognized at federal level. Such filings shall expressly affirm, secure, and permanently enforce plaintiff's inherent and inalienable rights in perpetuity. Rights that shall not be misconstrued, diminished, waived, or reclassified as privileges by any public or private entity at any time moving forward. This requirement is identical to the relief requested herein and expressly deemed non-negotiable. This filing shall explicitly extend to include the rights of the plaintiff, minor children, and direct generational bloodline, ensuring that all rights, protection, and benefits secured herein apply without restriction or limitation to said defendants. Any resolution, settlement, or satisfaction of judgment in this action, whether reached before trial, during trial, or after judgment, shall be a matter of public record and shall include the following non-negotiable, equitable, specific performance remedies in addition to any specified relief rewarded: immediate enforcement and encumbered transfer to the plaintiff of all commercial, contractual, and non-negotiable instrument previously created, executed, or tendered by the payment, included but not limited to vehicle title instruments, private credit authorizations, and property conveyance instruments, transfer of clear and marketable title to private land, real estate identified by plaintiff, free of all liens, adverse claims, encumbrances, and taxes, delivery of a fully insured and secured private vehicle of the plaintiff's choosing, free and clear of any lien, encumbrance, and taxes, execution of funding of full insurance settlement owed to the plaintiff and her children, including vehicle, home property, and generational life coverage, restoration of unrestricted access to private trust credit, and all associated accounts or authorizations without limitation or interference, immediate suspension of state and local court proceedings, orders, enforcement actions relating to plaintiff rights violations, pending final adjudication of this matter in federal court, full legal and beneficial ownerships and control of unrestricted access to all trust estates, accounts, and property created in the names of the plaintiff children, with immediate removal of any unauthorized third-party claims, trustee, or restrictions. Those equitable remedies shall be performed in addition to, without limitation to, any monetary judgment or damages awarded which plaintiff seeks in excess of $20 million USD fiat equivalent as set forth in this complaint. Plaintiff was born with sovereign rights that cannot be lawfully ignored, disregarded, or violated. Document reference presents a clear and chronological order of those rights being repeatedly infringed alongside the escalation of harm over time. This sustained pattern of violations has profoundly and adversely impacted the lives of the plaintiff and her children. This federal suit was avoidable entirely and arises directly from the documented timeline of events and the continued failure of all involved parties to uphold and enforce the plaintiff's rights. Let it be known that the plaintiff is not obligated nor inclined to reiterate the entirety of the evidentiary record within the statements of claims. The complete chronology, documentation, and supporting materials have been meticulously compiled in Exhibit D, document reference as which captures the orchestration of harm. Exhibit X, documents of harm, hardship, and violations committed by all involved parties since December 2023. It is each defendant's responsibility to exercise due diligence in reviewing Exhibit D document reference in its entirety to understand the scope of harm endured, to fully grasp the totality of opportunities they were afforded to correct remedy or cease such conduct prior to filing this federal suit. Failure to acknowledge or address the documented record shall not be construed as it's absent, but rather willful disregard and bad faith. Further expression of emotion does not negate the plaintiff's capacity for reason, law, or truth. The plaintiff's actions prove stability, intentionality, and alignment. The plaintiff has caused no harm. The record reflects who the real aggressors are. And then it is my signature and my affidavit page. And that is the full federal complaint. That unfortunately I have to wait to file, but everything is done. This has been one hell of a fucking fight and a battle and an experience, and I am fucking exhausted. And I can't wait until this is over. And I am about to go